I move amendments numbers 291 to 298. These are amendments to the Planning and Development Act of 2000. In relation to amendments 291 and 292, following commencement of Part 8 and Schedule 12 of the MAP Act 2021 on the 1st of October 2022, a potential technical requirement has arisen for an additional planning permission for projects in the maritime area that have already previously required consents in place, both in Ireland and in other jurisdictions, in the case of certain cables. These amendments address this issue. In brief, Part 11 of the Planning Development Act sets out certain certain types of development in the maritime area require planning permission, and it does not contain any specific exemptions that may already have other consents, particularly in the outer maritime area beyond the foreshore. Consequently, notwithstanding the foreshore consents that have already been obtained, in additional to an overarching project of common interest approval, an additional planning permission requirement emerges for certain types of projects, most notably cables, including interconnection. Amendments 291 and 292 address these potential additional consent requirements. They are limited in their application to those developments that A, already have foreshore consents in place, and B, in the case of larger scale developments in the maritime area, have had an environmental impact assessment or appropriate assessment, or both, carried out for the entire project. This will ensure that the State remains in compliance with the EU environmental law, and that the amendments cannot be used to circumvent such obligations where they arise. Section 182A of the Planning and Development Act of 2000 deals specifically with electricity transmission developments being carried out by statutory undertakers, transmission being high voltage cables. Amendment 291 inserts a new section 241, which amends Section 182A of the Planning and Development Act of 2000 to provide that where a proposed development for electricity transmission infrastructure is licensed under the Foreshore Act of 1933 before the commencement of this section, it does not require an additional consent under Section 182A. The section further provides that an environmental impact assessment and or an appropriate assessment must have been carried out before the issue of the licence, and that where provisions of the licence shall be deemed to apply to the development as a whole. The section also makes a technical amendment to Section 182A to clarify that the requirement for landowner consent prior to the application under Section 182A for the development in the maritime area refers to land in the maritime area. This is in order to avoid any conflict with provisions dealing with land in the area of terrestrial planning. Amendment 292 is linked to amendment that inserts a new Section 182AA to the Planning and Development Act of 2000. Section 182AA provides that an application under Section 182A of the Planning and Development Act 2000 is not necessary where an application is made to Umbró Pleanála under Section 291 of that Act in respect of a development in the maritime area for the purpose of electricity transmission. This is a clarifying amendment that removes the anomaly where the consent may be required under both Section 291 and Section 182A. Amendments number 293 deals with a transitional matter and provides a new Section 243, which inserts a new Section 278A into the Planning and Development Act of 2000. Section 278A disapplies the requirement for a maritime area consent for strategic infrastructure development, where the prospective applicant has entered into pre-application consultations with Umbró Pleanála before October 1st, 2022. This is to ensure that projects enter into the planning system under Section 37B of the Act prior to the commencement of Part 22 of the Planning Act, 21 of the Planning Act 2000, which introduced the requirement for a MAC, can continue in that consent process, notwithstanding the introduction of a new marine planning regime. This exemption is only applicable to strategic infrastructure development where the subsequent application for development consent is made before the 1st of October 2024. This ensures that where the development is not completed within the required timeframes, the obligations under the new maritime planning regime will apply. Amendment 294 inserts a new Section 244, which amends Section 280 of the Planning and Development Act of 2000. The amendment is intended to further address transition issues in the move from a system of operating under the Foreshore Act 1933 to the new marine planning system provided in the Maritime Area Planning Act, MAP Act of 2021. These provisions deal with a situation of projects underway at the time of the commencement of Part 8 of the MAP Act on the 1st of October 2022. Part 8 inserted into Part 21 of the Planning and Development Act 2000 bring the new maritime planning regime into operation. This amendment clarifies that new provision in Part 21 applying to development in the nearshore area do not apply to projects that are fully consented but have not yet commenced construction. Projects which are under construction but not completed, and projects which have been completed, as long as the development in question is subject of either a lease or a licence made or granted before the 1st of October 2017. This ensures that such projects are not subject to the revised legislative requirements introduced after they had completed the consenting process in place at the time. However, this application only applies where the development in question is completed within 5 years of the commencement of this section. Outside of that, the process will need to be restated as a new application, and an application for a MAC will need to be made. Amendment 296 inserts a new section 246, amending section 285 of the Planning and Development Act 2000. This is mirroring provision to that section 244. It is addressing the same transition issues arising in respect of the move from the existing regime operating under the Foreshore Act of 1933 to the new marine planning system provided in the Maritime Area Planning Act of 2021, but deals with the development in the maritime area other than the nearshore. Similar to section 244, this amendment clarifies the new provision, Part 21, applying to development of maritime area do not apply to projects that are fully consented but not have yet commenced construction. Projects which are under construction but not completed, and projects which have been completed as long as the development in question is subject of either a lease or licence made granted before October the 1st, 2017. This ensures that such projects are not subject to revised legislative requirements introduced after they had completed the consenting process in place at the time. This application only applies where the development in question is completed within 5 years of the commencement of this section. Outside of that, the process will need to be restated as a new application, and an application for a MAC will need to be made. This provision differs from section 244 in that it goes on to specify that any provisions of the lease or licence in place shall be deemed to apply to the development as a whole. This is included as a result of the fact that from the 1st of October 2022, the maritime area in which the authorisation is required has been extended to encompass the entire exclusive economic zone. Accordingly, any provisions attached to a lease or licence made or granted under the Foreshore Act 1933 are now to be considered as extending to the development generally. This is principally relevant to development such as cabling or pipelines. Amendments numbers 295 and 297 insert sections 245 and 247, which amend section 281(2) and sections 286 of the Planning and Development Act of 2000. They provide technical amendments required as a result of the amendment of section 287 of the Planning and Development Act of 2000, and as section 242 to ensure that land in sections 281(2)(b) and D and section 286 is clarified as meaning land in the maritime area. This is in order to avoid any conflict with provisions dealing with land in the area of terrestrial planning. Amendment number 298 inserts a new subsection into section 287 of the Planning and Development Act of 2000, provide that applications for offshore renewable energy related to port infrastructure can enter pre-application consultations with Bord Pleanála in the absence of a maritime area consent. The applications for such development will, however, be required to have a MAC in order to proceed with submitting a full application in accordance with section 291. This provision will shorten the overall consenting timelines for ports by enabling the MAC process and the pre-planning process to run concurrently. It will ensure that from a consenting perspective, the port infrastructure necessary for offshore energy development can be in place in time to meet the state's 2030 targets.
Thank you, Minister. Deputy Gould, do you wish to respond?
No, listen, these are very complicated, very complex amendments. And I made a point earlier, there's an awful lot in these, you know, and I'm just disappointed that, like, we're here now today and we're trying to get these done. And listen, we want to get it done, right? We want to, I have a few questions, and just how complicated these amendments are. I'm getting mixed up with the questions and the amendments because a lot of them are related, or there are sections that refer to different chapters, or different sections. I suppose one of the questions I have is in relation to what is the rationale for this change, as it appears to remove requirements from the planning oversight to a much less Aarhus compliant regime under the Foreshore Act 1933?
Well, certainly it's not less compliant than Aarhus, and I did state that generally around the public consultation at all levels of the planning, and just to assure that these amendments have been designed in a way that they are in compliance with the AR directive in accordance with the EU and Irish case law. Where an EIA is carried out, it must encompass the entire project. So again, just to give assurance to the deputy that they're no less compliant with Aarhus. So there's no changes being made to EIA or AA provisions themselves in relation to this.
Are we being asked here, Minister, to allow for other matters such as the foreshore applications to be transferred away from the Foreshore Act to be more a streamlined process on the MARA? But here we are being asked to do exactly the opposite, removing things from the Planning Act just to the Foreshore Act.
No, I mean, I think this is a streamlined process, is to give certainty to applicants, but also to ensure that those who wish to make observations have the right to do so as well. So I certainly don't contend that it's, I think from we're transitioning from what is an archaic consenting system under the Foreshore Act to a really streamlined, a much more streamlined consenting regime, which has been legislated by the MAP Act. So it is much more streamlined. It still allows for public consultation and public engagement, but it does give certainty and a much more streamlined process. So in terms of that, it avoids duplication of assessments. The amendments proposed create a pathway to move from the foreshore system into the new planning system. And the benefit of this approach proposed in these amendments is that it's an expedited and an orderly closure of the foreshore consenting system and move to much more modern consenting structures provided under the MAP Act.
Minister.
And one last question on this section, Minister. I have a number of questions, and I'm just conscious that there's an awful lot in this, but just one final question. There are issues with the internal numbering of paragraphs B and C, which makes it very confusing and unclear. Can this be corrected and clarified?
Certainly, Deputy, if he wishes to provide a further note or further briefing in relation to that, I appreciate what you're saying. It's a lot, and I do appreciate that. So if we can certainly facilitate further notes or further briefing if required in relation to that.
Okay.
Thanks, Deputy Gould. So on Amendment 291, the question is that the new section be there inserted. Is that agreed?
Agreed.
And then on 292,